President.
Oh, leader of government business.
No.
Yep.
Thank you, Madam President. I must apologize. I was told that Senator Hussain was scheduled to speak, so I was just coming into the chamber. Madam President, this debate is a whole lot about the bill, but flavored by a whole lot of what is not in the bill, and quite understandably so. This debate centers around the understanding of the critical role that a licensing committee plays in the landscape of Trinidad and Tobago. That landscape, of course, is spread across the understanding that the legislation, the licensing committees as introduced in 2014 by way of the amendments brought to the House and then to the Senate, that involves a number of pieces of law which articulate into the licensing committees and which this bill seeks to treat with by validating the actions of the quasi-judicial and judicial functionalities that operated under the law. Moneylenders are covered, pawnbrokers are covered, cinemas are covered, liquor licensing applications are covered. I'd like to point out, in grounding the argument as to constitutionality, that the test of constitutionality is really quite simple. In any one of the umpteen cases that treat with constitutionality, they really boil down to three limbs. One, there's a legitimate aim for the legislation. Two, the measures that the bill prescribes are rationally connected to that legitimate aim. And three, that the method of solution goes no further than it ought to in a society that respects democracy in the manner in which Trinidad and Tobago prides itself. That's really quite simple. Be it Northern Construction, be it Francis, Oaks, De Freitas, any one of the umpteen cases, Mirage, etc., that treat with what both the Privy Council and the Court of Appeal have settled as the law in relation to constitutionality. That, of course, is reinforced by an understanding of Section 13.2 of the Constitution. Section 13.2 says you may abrogate Section 4 and Section 5 rights, and yes, this bill treats with Section 4 and Section 5 rights in terms of due process, in terms of rule of law, in terms of a number of the aspects, equality of treatment. All of these things find themselves together with the general rule that one ought not, as a legislature, to interfere in the separation of powers doctrine. So those two put together bear the need when we come to providing an indemnity and immunity from prosecution, as we see in Clause 7. We see the need for Sections 4 and 5 rights and separation of powers constitutional rights to be considered in the context of Section 13.2 of the Constitution. Section 13.2 of the Constitution says you can traverse rights that are set out in 4 and 5, and I add now the larger doctrine of separation of powers, bypassing the law Firstly, with a 3/5 majority, if that's the rule of entrenchment. It may be different if you get to Section 54 of the Constitution, which can talk about 3/4 majority or 2/3 majority. You can do it if you have 3/5 of the support of the House that is passing it, and if it is respected in a society such as Trinidad and Tobago, which has regard for the rule of law that we do and the democracy that we do, and that's where the proportionality argument comes in the three limbs. So, we've heard Senator Mark and Senator Mahabir both speak to issues of constitutionality potentially being treated in this debate. They are correct. There are issues of constitutionality being treated. Senator Vera has, in like fashion, also treated with that, and he's pinpointed it in the body of the clause that causes him the most concern, which is Clause 7 of the bill. Is there a legitimate aim? Yes. What's the legitimate aim? Number one, as Senator Vera mentioned, the magistrates' protection legislation is not 100% in cover. We recently amended the magistrates' protection by an act of Parliament, which this Senate passed and the House passed, and what we did was to broaden the level of protection, but there was not 100% protection given. Back then, as Attorney General, I gave an undertaking to come back to the issue after we had finished the divisioning of courts exercise. As honorable members that have served in this House together with me in this particular session are aware, all undertakings are met by this government. We have given undertakings. Indeed, when Senator Ramdeen contributed in the manner that he did, we gave several undertakings, and he was witness to the fact that we came back to many of them. So number one, the magistrates don't have protection of the type that is required. Number two, we heard Senator Mahabir, and I congratulate him. It's the first time I've heard him speak in this House. Senator Mahabir raised quite an interesting point. Senator Mahabir, in talking about the separation of powers argument, said, he's quite correct, the Honourable Senator, that there should be a loath approach, a reluctance for the legislature to involve itself in the acts of the judiciary. And the Honourable Senator quoted from some constitutional law that spoke to those aspects. But respectfully, the argument is to be distinguished by the fact that the precedent that the Honourable Senator was referring to, the textbook that the Honourable Senator was referring to, was where the Parliament involves itself in acts of the judiciary in a particular circumstance, which is not this. It's true that this bill seeks to treat with an involvement in judicial function, decisions taken by the judges. But it is absolutely true that we cannot forget the real facts. It was the executive of the Republic of Trinidad and Tobago, the sitting government of Trinidad and Tobago, the United National Congress, Kamla Prasad Bisesa-led government, that proclaimed the law to operationalize the 2014 amendments. So an executive act, a government's act, and let me make it abundantly clear, it has nothing to do with the fact that the law was passed by everybody. That's the Parliament passing law. You operationalize law, you assent to law, you proclaim law only by act of the Cabinet of the Republic of Trinidad and Tobago. It's considered on two occasions, as a matter of fact. A note is taken with respect to proclamation or the invocation of assent. That note is considered 1 week, and then another week later they confirm the act that the Cabinet is being asked to consider, unless the Cabinet approves and confirms on the same day. So the only entity that could possibly proclaim the law was the United National Congress, which makes somewhat of a mockery the arguments put forward by Senator Haynes in her complaint about us validating for ourselves. No, we are validating to fix an insane act of a sitting government. What is insane about it? You are proclaiming law on a structure that doesn't exist. So, coming to the point of constitutionality raised by Senator Mahabir, the distinction to the senator's argument is to be found in the fact the Parliament is proper to involve itself in an act of validation because we are fixing something that the executive foisted upon the judiciary. No magistrate and no judge and no licensing committee foisted that law onto themselves. Anand Ramlogan as Attorney General, sitting then as the advisor to the cabinet, Mrs. Prasad Bisesa, the leader of the opposition, sitting as senior counsel in that cabinet, they foisted the law upon the judiciary, in this case the magistracy, and the clerks of the peace. So Senator Vera asked the pellucid questions. Well, what are the options available to us? And I'm still on the legitimate aim, because now my legitimate aim can be summarized to the point, we are protecting the magistracy and the clerks of the peace and the licensing committees from that which a government foisted upon them without choice. Nobody else proclaimed the law. Nobody else caused sitting magistrates to consider thousands of matters. So legitimate aim number one, we're protecting the magistrates from a recalcitrant government then sitting. I'm being straightforward now, and I'm not going to pull punches, because punches were not pulled in this debate. Legitimate aim number one. Legitimate aim number two. Honorable senators are well aware that the laws of the Republic of Trinidad and Tobago include the Exchequer and Audit Act, the Constitution. The Auditor General is the creature at law that must decide whether the collection of revenue and non-revenue, because you have interest monies, you have fees, and you have revenue. Interest monies means money that's not yours. For instance, a collection in court for maintenance payments that are paid into court, that does not belong to the court, it belongs to the person for whose benefit it is paid. That's interest money. Non-revenue money is revenue of the type which is fines and fines and penalties. When you're brought to court and told pay a $5,000 fine, you have a penalty to pay. That's non-revenue money that's collected by way of fines. And the third species of money that is collected is, of course, fees, revenue money, taxation, etc. But, honorable senators, the second legitimate aim of this law is to make sure that the Auditor General can certify the monies that were paid to the magistracy, the licensing committees, for the entire time that the court sat via a magistrate to do something which they couldn't do. Because the 2014 law came in, fines and fees were accepted by a UNC government proclaiming law that it should never have proclaimed, and therefore to solve the collection of revenue for thousands of matters. Obviously, we can't put the taxpayers of the Republic of Trinidad and Tobago into the jeopardy of them saying, "Give me back my money," to put it quite boldly, because there would be nothing wrong with the person who had an expired license coming forward with an insane argument to test in the court to say, "I had my license, but you should never have accepted my money." And this is Trinidad and Tobago, you know, ladies and gentlemen, honorable senators all. This is Trinidad and Tobago. I put no argument past those who have time to waste. For instance, we have people in the public domain claiming that a Privy Council decision on a basic point of leave to proceed with judicial review is landmark law, trite law. And when we look at the collection of revenue under this law, the Auditor General is going to have a serious problem on the Auditor General's hands. And I've heard honorable senators, you know, Senator Haynes amazes me at times. We need the numbers, we need the statistics, we need the data. I gave honorable senators data demonstrating close to 14 1,000 matters on the liquor licensing side alone. And the liquor licenses are not annual licenses, you know. There are 12 types of licenses: occasional licenses, spirit dealers licenses, grocers licenses, yearly licenses. They're all special licenses. There are multiple forms of licenses. But I say that I'm amazed by Senator Haynes because it matters not if there were 14,000 or one. The Auditor General cannot have an easy ride in trying to figure out the collection of revenue. Why? Because it was ultra vires. It was unlawful. You were collecting people's money on the back of a law that did not exist because it was repealed. And the judicial function of having collected that money now puts the entire process into odium. And then we hear Senator Haynes tell us about we are correcting things for us and that's self-serving. No, we are correcting things for you. For you. 4 years later. Very good point. Let's deal with that. This bill is bill number 2 of 2018, in case you didn't notice. Number 2 of 2018. To cause the population of the committees, we had to make sure, sometimes my contributions are so good that I have backup music, Madam President, but to cause the population of these committees, we had to engage the judiciary, the chambers of commerce, the relevant authorities, to populate them. At the same time, there's another argument that's afoot. It's true that the 2014 law and the use of the committees may have been a good idea, but perhaps not the best idea. And a lot of us had a lot to say about that, how it could be improved. I agree with Senator Vera, and I compliment him openly. I agree with the fulminations of Senator Mahabir on some of the positions that he's brought forward. I agree that we really ought to have a functioning aspect that can really do the job. Senator Mahabir raised the point, truthfully, that the quorum for committees was hard to obtain. Why? Because the clerks of the peace are in a state of disarray. The chambers of commerce needed to apply for alternates, and principles. There needed to be a population. It took our cabinet 3 attempts to install these committees because we had to go through the process of consultation to get the names, get the nominees, have non-objections, have the Chief Justice do the appointments, change out the clerks of the peace because they rotate every 21 days. A clerk of the peace is rotated every 21 days. And therefore, if you name clerk X, 21 days later you had to name clerk Y. But we couldn't go to the level that we've been invited to go because we were engaged in a by far more serious exercise. And I don't mean that disrespectfully. This country is crying out for criminal justice reform. Criminality is the number one issue in this country next to the economy. People feel that crime is run away. They ask what's going on in the prisons. We had public sentiment in Trinidad and Tobago for escaped prisoners that members of the public were saying, hey, it's okay, them fellas good to escape because they want a trial. Somebody on a charge for murder is receiving the public sentiment of support because poor fella, he need a trial. Well, you know, I understand that because you do need a trial. But what is critical in our arena is to understand what makes a trial happen. We keep getting recommendations as anchored in this bill in the operationalization of the committees in terms of its purpose. We keep getting recommendations on the criminal justice system which tell us effectively, change that tire. Give me a new tire. Let me draw the analogy. To have a committee sit, to have a court sit, to have a criminal court sit, it is not only the court that causes the trial to happen. You need a judge, you need a prosecutor, you need a defender, you need a witness, you need the evidence, you need the rules of court, you need to have the transportation system working to move them forward. You need to have medical experts. You need to have ancillary witness support protection. There are multiple pieces to that arena moving ahead. And when the government, on the backdrop of the issues surrounding the 2014 Licensing Committee, understands that, look, these committees really need to work better, surely honorable senators can take, in this case, not judicial notice, but legislative notice that we've come to this parliament and we've implemented criminal proceedings rules. We've introduced a 77% increase in judicial capacity. We have birthed a public defender system which should come live in a month or two. We have introduced computerization in the courts. We've introduced a criminal division, a family division, opened children's courts, done the regulations for all of these entities. Criminal responsibility. We've dealt with plea bargaining, maximum sentence indicators, judge-only trials. We've dealt with white collar as a mechanism to treat that. All of these things are not textbook, honorable senators. They're in operation now. First plea bargaining case under the legislation, done. First and second judge-only trial, one for murder, one for money laundering, done. 2 children's courts to deal with crimes relating to children, done. Criminal proceedings rules introduced since 2016. 400 maximum sentence indication, MSI, Goodyear principal hearings done in 1 month in August last year alone. Does that sound to honorable senators as if there isn't an anxious scrutiny of the system or an anxious intent to operationalize the system? Far be it from the case. The introduction of the magistracy computerization formula. We took what was introduced in the Family and Children Court, which the Honorable Chief Justice himself obtained from the government of Nigeria, practically for free. Then the government of Spain bettered the software. We put in an entire computerization schedule for the Family and Children Division for the children's courts, and we replicated it in the magistrates' court, so that we actually no longer have a clerk sitting down with a longhand book, writing till the pen break and the finger get cramped, and calling your name staccato, go down the call of the corridor where you say, John Brown, and you hear the echo, John Brown, John Brown, John Brown, John Brown. By the time the name reached down the corridor, John Brown name changed to Jane X. Those of us that have actually been there understand the truth of what I'm saying. But the point is, having rules of court, attendances at time, processes going, all fit in with this law. Why? Because when we launch next month, in June, the computerization and electronic payments in the Registrar General's Division, so that rat infestations don't hold sway over your need to attend, as happened, because an outgoing government left a building which was less than adequate, and a new incoming government is outfitting new premises as we speak. The electronic payments make a difference because 100,000 cases from the Motor Vehicle and Road Traffic Court come out of the system, which leave more room for the committees to operate, for alternative dispute resolution to go to work. More importantly, Mr. Vice President, the Cabinet of the Republic of Trinidad and Tobago last week gave the final approval for the radical transformation of the operationality of the magistrates and masters, the criminal masters. Why? The civil system began to work because we put in civil proceedings rules, but we gave judges computerization and judicial support officers, judicial research assistants, and teams to work with each judge. We have approved hundreds of positions just last week, 214, 178, 81, 61 positions, so that every magistrate, every criminal master obtain a team of 5 judicial research assistants, judicial support officers, etc. In other words then, we are operationalizing the same criminal division and traffic district courts that we birthed, this Senate birthed in this session of the Parliament. This 11th session of the Republican Parliament is the time when we did this. So gone are the days where you pass a law in 2011 and you just don't proclaim it. Like DNA, for instance, if you recall, the DNA law was passed in 2011. It was only under this government that the DNA law and the regulations were put into effect. So, legitimate aim is being serviced by the operationalization, but most respectfully, we couldn't take the invitation to change the tire on the car at this point until we had a chassis, an engine, a steering wheel, some gas, and some mechanics working. We had to get the thing moving. So, I want to thank Senator Rambarat in particular for really taking care of the rational connection as it applies to sections 4, 5, clauses 4, 5, 6, and 7. The bill is very specific. The language is rather terse. And it's true in sections, clauses 4, 5, 6, and 7, there is one constant thread that says would have been lawful and valid had the act not come into force. So let's look at section 7, clause 7. Notwithstanding any law to the contrary, no legal proceedings or any other action of any kind shall be commenced or continued against a person in respect or in consequence of an act, decision, omission, or proceedings of a licensing committee done, taken, made, or conducted during the specified period, if such act, decision, omission, or proceedings would have been lawful and valid had the act not come into force. That formula of language, terse as it is what the government put in, what the CPC's department put in to make sure that there was no blanket immunity, to make sure that people were not excluded out of claims which they would otherwise have had for unlawful acts or invalid acts under the law which we're saving. So, that's why, and I wish to thank Senator Vera for giving away on so many occasions, as he did, to allow me to put that point onto the record, because my learned friend Senator Vera is a powerfully convincing advocate. And when Senator Vera says something in this Senate, I listen well, and we all on this government side listen well. I'm sure all of us do. Even though this is one of the rare occasions where Senator Vera and I don't agree, because I am minded to accept the toast. You know what? This is Trinidad and Tobago. This is a place where the law is evolving constantly because of the nature of our society. Let's take the merit of the argument. And we respectfully believe, agreeing to disagree, but then agreeing that Senator Vera's way should be had, we propose an amendment to clause 7, which is to allow, out of an abundance of caution, we'll put 7 the way it is, we'll make it 7 subclause 1. And then we propose to add in a subclause 2 and a subclause 3. The subclause 2 will say effectively, nothing in subsection 1 shall affect the right of any person to any legal remedy which he would have had in relation to any act, decision, omission, or proceedings of a licensing committee if the act had not come into force. And then we propose a subsection 3, which says, notwithstanding any law to the contrary, a legal remedy referred to in subsection 2 may be obtained in the same manner that it could have been obtained had the act not come into force. In other words then, let's not rely upon the terse, tight description of the caveat to sections, to clauses 4, 5, 6, and 7. Let's expand it. Perhaps Senator Vera is having a positive influence on a topic that I know he's very passionate about. Senator Vera, if I may be bold, Madam President, is the king advocate for plain English, plain and ordinary meaning, simple legislative speak. It's where other jurisdictions have gone. The United Kingdom, Canada, a number of jurisdictions rely upon that. We, in our colonial ways, have been hard to let go of Latin, ex proprio mutu, of mutatis mutandis. We have been loath to let go of our Latin and complex language description, and I think the law is slowly beginning to warm into that. So perhaps this is the opening of a door on that effect. I will confess to you that the learned senior counsel that occupies the chair of the Chief Parliamentary Council, in his very gentle demeanor, Mr. McIntyre, SC, is quite insistent, as is Ms. Ida Eversley, that we ought not to breach the hallowed principles and celebrated principles of legislative drafting. Senator Thompson, IE, is witness to the battle we have on the passive and active voice issues and the singular and plural issues, as was Senator Elton Prescott, who was the ubiquitous spotter of the ubiquitous element, which is the semicolon or colon, all of which make deep and simple impact upon laws as they are construed. So, honorable senators, I thought this bill was a fairly simple bill. It touches a nerve which reveals a desire for better. I hopefully have put before the honorable senators an explanation as to why we could not come deeper into the 2014 law. I'd like, respectfully on behalf of the government, to allow us the opportunity to treat with the deeper reforms. Those deeper reforms are important. We've taken careful note. As we operationalize the magistracy, registrar, and clerk of the peace, because you are aware that in the criminal division, we abolished the clerk of the peace. That post should be filled by the end of the month. Advertisements are out in the judiciary, and then we will have, for the first time in the history of the Republic of Trinidad and Tobago, and in the history of Trinidad and Tobago, if you go back to the colonial roots, it's the first time we'll actually have lawyers qualified at the bar sitting as the registrar and clerk of the peace of the court, because we have been turning a collective blind eye to a breach of the Legal Profession Act, where clerks of the peace who are not attorneys at law breach the law every day in rendering legal advice in relation to warrants, summonses, etc. And that is not something that one can tolerate without solution. We've brought the solution for that. We believe that the proposed amendments to Clause 7, which I will ask to be circulated now, will take us to a zone of safety in having an express statement of the caveats which we believe were tersely stated in the qualifying elements of clauses 4, 5, 6, and 7. We do believe that this is a legitimate aim. I'll be frank as I wind to a conclusion.
Before you wind, sir, Madam President, through you, I would like to ask the distinguished Attorney General whether the government would be inclined, through the leader of government business, to look at us proposing to the Senate Standing Orders Committee the insertion of a provision that would avoid this situation from occurring in the future, regardless of the government in office. The establishment of a post-scrutiny legislative committee. No, we cannot do it on the floor.
I thank the Honourable Senator. It's a point, Madam President, that was raised in the debate. I think it was, forgive me, I can't remember whom, I believe it was on the opposition bench that said, we need to find a mechanism to avoid this circumstance. Quite frankly, there is a mechanism. It's called the Government of the Republic of Trinidad and Tobago, otherwise known as the Executive. And yes, these kinds of examples cost the taxpayers millions of dollars. I'll give you 3 examples. the proclamation of the child rehabilitation centers done by Attorney General Anand Ramlogan. That was proclaimed into law that said every child who is in conflict with the law and who is to be remanded has to go to a child rehabilitation center. That was the law. They proclaimed the law. There were no child rehabilitation centers. Interestingly enough, persons went before the courts and sued the government. Actually, whilst I was being sworn in as Attorney General on the 9th of September 2015, I had to step aside and take a call from the Solicitor General's department to tell me that they were in court on a claim that there was a breach of the law because there were no child rehabilitation centers. Guess who the lawyer was acting for the claimant in court? Anand Ramlogan himself was before the court suing the state for failure to have a child rehabilitation center when the UNC government proclaimed the law with no child rehabilitation centers. The state paid millions of dollars in damages and in accommodation expenses for children. Millions of dollars. Example number 2. This law was proclaimed by Mrs. Prasad Bisesar's cabinet, a UNC cabinet. We have now exposed the taxpayers to the Auditor General asking a question, well, what are you going to do about all of that money you collected illegally? We are now exposing the magistracy, as Senator Vera quite capably demonstrated, to legal challenge. Are we going to rely on the doctrine of necessity? Are we going to rely on omnia praesemuntur? Are we going to rely on other maxims of law? Are we going to let the thousands of applicants come forward? It would be untidy, and that is why we recommend the validation in simple form, and that is why we also recommend the ex post facto application, the retroactivity. And by the way, there is nothing wrong with retroactivity if it is done in a particular way. The leading case in the root origin of the Privy Council's decision is Leonage. It's a case out of Belize, and in that dicta, we have clearly set out the fact that ex post facto, non-ad hominem legislation done in the right circumstances is perfectly permissible, as does Bennion statutory interpretation, Francis Bennion, 5th edition, not the 6th as Senator Vera had pointed out, but they go on in the further examples to say that it is entirely appropriate to do so. So that was example number 2. And of course, example number 3 is to be found in no less a feature than Section 34. Section 34 was proclaimed solely by a UNC cabinet, and a very useful logjam dynamite provision, which is Section 34, which Senator Vera and I both sat in that parliament and passed. I, as opposition member, Senator Vera on the independent bench, everybody agreed Section 34 was a good provision, but 3 undertakings were given. Make sure you have masters of the court, make sure you have rules of the court, and make sure that you have courts. Of course, that only came to life when this government came into effect, which is why the state paid millions of dollars in legal fees, which have cascaded into years of delay on the back of Section 34. So I'm giving Senator Mark, in answer to his inquiry, 3 live examples of how millions of dollars of tax-paying dollars can be wasted by way of the abuse. But the mechanism that exists is really a cabinet doing its job.
There's another way. When the Children's Act was being reformed, if I may, Madam President, I was on sabbatical at the time, and I wrote a series of articles in the Trinidad Express. One of the recommendations I made was for an implementation schedule along the line of the Children's Scotland Act. Had they put the implementation schedule and deferred that section dealing with the rehab, that would not have happened with the rehabilitation center. But
Senator,
free legal advice was not appreciated.
Thank you, Honourable Senator. I think the Honourable Senator will be warmed to know that under this Attorney General, we do everything by way of an implementation schedule. Everything. Literally everything. So it's working in the current state. Senator Mark may be on to a good idea. I'm not quite sure if the Parliament really ought to involve itself in the in the executive functionality of what an Attorney General should be doing. An Attorney General should be proclaiming law in consultation with others without breaching the rules of anticipation. We'll hear about that in a bill that has just come from the House to cause an amendment to the preliminary inquiry's abolition laws. And I'll explain that in a different debate. But what I'm saying is that may be an option. I'm not warmed to the idea because really only a government can speak to its operationalization. And a government is held accountable for it. I mean, I'm sure that the last government was held accountable for Section 34. Whether it'll go far enough in today's modern world of what has happened in Europe and elsewhere in the world in terms of xenophobia and polarity demonstrating itself to be real is a different question.
Attorney General, you have 5 more minutes.
Much obliged, ma'am. So, Madam President, I humbly recommend this law. It is open to the honourable members to cause this bill to fail. If the honourable members do not vote for this law, it is an entitlement. There will be no aspersion to anybody's character. As the purveyor of the legislation, having demonstrated, I hope as succinctly as I could, the legitimate aims that reside in this legislation, having listened to the exhortations of my learned colleague, Senator Vera, as to a manner in which we could improve the terse language which relied.
Thank you, AG. And may I just say I have read the amendment and it satisfies all my concerns.
Thank you, Honourable Senator. So, Honourable Senators, I commend this bill for your consideration. I urge your support. I can have no fault if you don't. At the end of the day, it will be the best effort that we can bring to this Parliament in the circumstances that we have, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Validate the Constitution of Licensing Committees established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters, be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Validate the Constitution of Licensing Committees established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Validate the Constitution of Licensing Committees established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Validate the Constitution of Licensing Committees established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honorable Senators, I remind everyone that there are 8 clauses and a preamble in this bill. Attorney General, are you ready?
Yes, ma'am.
Clauses 1 to 6.
The question is that clauses 1 to 6 stand part of the bill. The question is that clauses 1 to 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 6 now stand part of the bill.
Clause 7.
The question is that clause 7 stand part of the bill. Honorable Senators, we have the proposed amendment circulated on behalf of the Attorney General. Go ahead. Attorney General.
Madam Chair, we took note of the recommendations coming from the honourable senators, led by Senator Vera, and we recognize that there is merit in enlarging the caveat language. In those circumstances, we propose that Clause 7 be amended in the manner circulated to make it expressly clear that we are preserving all the rights of litigants in all forms and fashions to challenge the things which they ought to challenge or consider that they ought to challenge. This would have the effect of, I think, making proportional any allegation as to an intrusion into the separation of powers, and would definitely preserve rights in an expressly larger fashion than the language which was previously circulated to Clause 7 at the second part.
Members? No? Honorable Senators, the question is that Clause 7 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 7, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 7, as amended, now stands part of the bill.
Clause 8.
The question is that Clause 8 stand part of the bill.
Madam President,
Yes.
with respect to Clause 8,
Yes.
I'm reading this clause that proceedings commence during the specified period, which would have been lawfully and validly commenced if the act not come into force may be continued and dealt with under the Liquor Licensing Act. My reading of this, the word may, it suggests to me that the continuation of proceedings that had happened between this in the specified period, it is not automatic. That word may. Who is to determine which actions should continue? And what are the conditions that will determine what actions should continue? And my feeling is the word may should be replaced with shall.
Any other questions or comments? Senator Thompson,
Sorry. The mic is on, right? Commence if the act had not come into force. There's a word missing there.
Attorney General.
On the easier of correct points, I thank Senator Thompson-Aye for policing the language of this clause. She's perfectly correct. The word had has been inadvertently omitted from the fourth line, just after the word act, and before the word not, the word had should be inserted. And in relation to the inquiry from Senator Mahabir, if I could just perhaps shed some light on it. any proceedings commenced during the specified period, and the specified period is the date which it was repealed to the date that we'll proclaim this amending validation act, right? Pursuant to Liquor Licenses Act, which would have been lawfully and validly commenced if the act had not come into force, may be continued and dealt with under the Liquor Licensing Act. It's specifically to take care of that gray zone of the committees already having come into effect. Because what happened is the magistrates have now stopped performing the function unlawfully, and the licensing committees are now in fact in operation. But there are some legacy matters which certain magistrates have held over, and that's really because of the closure of some courts after the earthquake, lists being deferred, etc. So what we allowed was the continuation of matters which were already in train. So we took care of the two circumstances because permutations and combinations have to be factored. So clause 8, in the use of the word may, the Honourable Senator is correct. Somebody has to decide. In this instance, it'll be the court to decide. So if you're before a magistrate on an existing matter that has not yet concluded, the magistrate may say, look, in the interest of justice, and so that you don't have to reconvene under a new committee and start all over again, we'll just finish it under the law, provided it was something that was caught in the specified period, and that's calculable by way of reference of the matter. Yeah. Similarly, it may be that you wish to take it over under the new law because you are not as far gone as you were under the old law. So I hope that that lends some clarity to your inquiry.
I'm attempting to understand. It's just that my reading of this, by the use of the word may, I get the feeling that you're trying to box in, or you're trying to clamp down on what is the matters that are presently before the court.
Not really. If we had said shall, then we'd be boxing in. If we said shall, it means that everything that was in train would not have the option to come under this law. If we say may, you have the discretion in the interest of justice as the clerk of the peace or the magistrate may decide to go in whichever way was opposite to savings and efficiency.
Senator Amin?
Yeah, Madam Chairman, through you to the Attorney General, in a practical sense, I feel that there will be a time period between the passing of this bill and its assent, when it is proclaimed and it is in fact enacted, put into action by the court. In my view, there will be sufficient time for the winding up of the existing matters under the old practice of the magistrates, right? My concern is that, while I feel that there will be sufficient time to wind up the existing matters, my concern is that after, in addition to the new matters, the new ones, because of the word may being there, doesn't necessarily mean that they will be treated accordingly, right? So while I understand why you choose to use the word may to give space for those matters already in train, at the end of those matters, the may still remains, and there still will be a discretion, which I feel should not be there. So I'm endorsing my colleague's point, but just from a different perspective, and suggesting to you that there will be enough time to wrap up those matters that are already in train.
Right. Attorney General, just 1 second. Yes. Senator Vera.
Thank you, Chair. I understand the point, but if I may, from Thornton's legislative drafting, we are looking at the difference between a power and a duty. So the distinction between a power and a duty appears to be straightforward and clear-cut. A power implies a measure of discretion. The holder of the authority is authorized or permitted to exercise it, but need not do so. The authority is classified as permissive and therefore power. The word may should invariably be used to confer power. If the holder of the authority is obliged to exercise it and some act must be performed, the authorities are classified as obligatory and therefore a duty. A duty may be expressed either as a particular rule or as a standard. It may be expressed positively or negatively. The words shall and must are commonly used to impose a duty. Now, in light of that, I think that this is meant to be a discretion and not a duty. So I think may is the correct word.
Correct, may I?
Yes.
I thank Senator Vera for going literally to the source of authority. Thank you. It is properly to preserve a discretion because it is the presiding officer, be it clerk of the peace, in the licensing committee structure, which is up and running now, or the magistrate. And just to point out that this law has no proclamation clause. This law comes into effect on assent. The assent is done by way of the legal report from the Attorney General. I just signed one a minute ago. They're done almost the day after. So the Solicitor General prepares the assent. We then write to Her Excellency the President, and what can happen is that this can become law in a matter of days, which is the intention. Because we are certainly not able to contemplate all the permutations and combinations of thousands of matters, it would be imprudent of us to use the word shall, because it is properly rooted in a power, and that power ought to be discretionary. If we were to use shall, we may unwittingly be inviting the court to determine that we're breaching the separation of powers principle by directing the court to comply with only one route, that is the old law. May allows for the discretion to act on the power route basis. So in all the circumstances, we are confident that may is the correct expression.
So, Honourable Senators, the question is that Clause 8 be amended as follows. In the fourth line, to insert the word had after the word act and before the word not. Yes, those in favour say aye. Aye. Those against say no. The ayes have it. Clause 8. The question, therefore, is that Clause 8, as amended, now stand part of the bill. Those in favour say aye. Aye. Those against say no.
Madam President, wasn't there at the line under the Liquor Licensing Act, the 1, 2, 3, 4, the fifth line, as if it had not come into force? This is...
We dealt with it,
You dealt
Senator.
with it?
Yes, the had comes under the fourth line, not the final, not the penultimate line, the second to last line.
The fourth line,
Right
okay.
where your finger is.
Okay.
So, Honourable Senators, the question is that Clause 8, as amended, now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 8, as amended, now stands part of the bill.
The preamble.
The question is that the preamble to the bill be approved. Those in favour say aye. Aye. Those against say no. The ayes have it. The preamble to the bill is approved. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Madam President, I wish to report that a bill entitled An Act to Validate the Constitution of Licensing Committees, established under Section 5 of the Liquor Licensing Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Validate the Constitution of Licensing Committees, established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters. Those in favour say aye. Aye. Those against say no. The ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Validate the Constitution of Licensing Committees, established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters, be read a third time and passed.
Honourable Senators, the question is that a bill entitled an act to validate the constitution of licensing committees established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. As you know, this bill requires a special majority, so the clerk will conduct a division.
Mr. Khan,
Yes.
Mrs. Batiste Primus,
Yes.
Mr. Rambarat,
Yes.
Mr. Sinanan,
Yes.
Mr. Moses,
Yes.
Ms. West,
Yes.
Mr. Singh,
Yes.
Mr. Cummings,
Yes.
Mr. Lehant,
Yes.
Dr. Henry,
Yes.
Mr. De Freitas,
Yes.
Mr. Dookie,
Yes.
Mr. Simonet,
Yes.
Mr. Young,
Yes.
Mr. Mark,
Yes.
Ms. Haynes, Ms. Amin,
Yes. Yes.
Mr. Obika,
Yes.
Mr. Mahabir,
Yes.
Mr. Richards,
Yes.
Mr. Vieira,
Yes.
Dr. Dial Singh,
Yes.
Ms. Dunrai,
Yes.
Mr. Timal,
Yes.
Mrs. Thompson-Aye,
Yes.
Dr. Dylan Remy,
Yes.
Ms. Mututa,
Yes.
What do you have, ma'am?
26 and 10.
Honorable Senators, the results of the division are as follows. 27 members voted for the bill, no one voted against it, and no one abstained. The bill has therefore been passed.
A bill entitled An Act to Validate the Constitution of Licensing Committees established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as a grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Tuesday, 28th of May, 2019 at 1:30 p.m. in the afternoon, obviously. And that will be Private Members' Day, and we will be continuing debate on the Election and Boundaries Commission matter.
Honorable Senators, before I put the question on the adjournment, leave has been granted for one matter to be raised. Senator Mark.
Thank you, Madam President. Madam President, the population of Trinidad and Tobago is demanding of the government to provide it with reasons for authorizing the Urban Development Company of Trinidad and Tobago borrowing some $180 million from NCB Global Finance. Madam President, something very curious happened in this country. In the Trinidad and Tobago Gazette, dated the 22nd of November 2018, there is a section of that Gazette that speaks to the reassignment of responsibility to the Prime Minister. And I want to quote what this says. It says, "It is hereby notified for general information that Her Excellency the President, acting in accordance with the advice of the Prime Minister, under the provisions of Section 79(1) of the Constitution of the Republic of TNT, has assigned to the Honorable Keith Rowley, MP, the Prime Minister, the responsibility for the administration of the Urban Development Corporation of Trinidad and Tobago, UDCOT, with effect from the 14th of November 2018. G. Serrett, Secretary to Her Excellency the President." Madam President, this reassignment, which was under the control of the Ministry of Housing and Urban Development for 8 or thereabout years, mysteriously found its way under the office of the Prime Minister. And Madam President, you know what is even more curious? I know he has authority. I know he has authority. I'm not querying that. That's why I read the authority here. So, Madam President, what happened is that this thing took place on the 14th. Madam President, curiously, on the 15th, according to the Prime Minister himself answering a question in the other place, the loan for $180 million was executed just accidentally and coincidentally on the 15th of November. So just 24 hours after the transference of UDCOT to the Prime Minister's office, this loan was executed. You know on whose behalf? It was executed on behalf of UDCOT. But the company, the mortgage finance company, or the finance company that executed that loan was known as NCB Global Finance. This is a foreign registered company in Trinidad and Tobago, owned by a fellow called Michael Leachin, a Jamaican who lives in Canada but born in Jamaica. Madam President, I want to bring to your attention some very curious developments that have taken place in our country. And that is why I think the public is demanding from this government. Why did the government go to NCB Global Finance and not to the Republic Bank, not to First Citizens Bank, not to Answer Merchant Bank, not to Royal Bank of Canada, but you know, Madam President, to NCB Global Finance? The Member of Parliament for Port of Spain North, St. Anne's West, his brother, who put out a big statement in the Newsday 2 days ago, saying that he's the brother of the Member of Parliament for Port of Spain North, St. Anne's West, is the Managing Director of NCB Global Finance. And not only is he the Managing Director and CEO, he's also a Director on the NCB Global Finance. Madam President, I want to bring to your attention what happened with this company. This company that mysteriously, in various incarnations, came into existence under the name of NCB Global Finance in 2014. It started off with an asset base of $115 million. Madam President, that was at the 30th of September 2014. By the end of September 30th, 2015, it went to $132.3 million. By the end of September 30th, 2016, it jumped to $218.8 million. By the end of September 2017, it went to $350 million. Madam President, this is a foreign company owned by a Jamaican. I have nothing against Jamaicans. But what is serious is that the brother of the Member of Parliament for Port of Spain North Sense, Hans West, is the managing director and CEO of this company. Madam President, the customer deposit base, according to research that I have conducted, in 2014 stood at $71.5 million. In 2015, we were still in office. It went to $83.8 million. The Red and Ready Brigade came into power. In 2016, it jumped to $160 million. Madam President, by 2017, it went to $269 million. As soon as the Red and Ready Brigade arrived on the scene, Madam President, you know what is interesting too? Interesting? The capital injection for this NCB Global remained stagnant at 82.9 million 2014, 2015, 2016, 2017. Madam President, I want to give you the answer to the riddle. This government used state institutions in order to bolster the financial asset base of this company called NCB Global Finance.
Senator Mark, please. What you're saying there contravenes the standing orders. You need, please, to withdraw that. You can make your presentation in another week, but you cannot say what you, I can't.
Madam President, what I'm going to show, Madam President, all right, I will draw, but I will deal with the state institutions, and you will draw your own conclusion. But I will, all right, you don't have to go on the platform. Good. I have no license on the platform. It's not in here. Yes, I know, I understand. But this will be said on the platform. Madam President, let me tell you what went on here. There's something called the Home Mortgage Bank. You know what these fellas did with Home Mortgage Bank? Home Mortgage Bank had 33.8 million JMMB shares. JMMB was initially owned by Clico, but it was divested in 2011. You know who bought the bulk of those shares? Michael Leachin, 26% of JMMB. Madam President, Home Mortgage Bank is owned by the people of Trinidad and Tobago. I call on the Minister of Finance to tell this country who authorized him to hire NCB Global Finance to take our 33 million shares and sell it on the Jamaican Stock Exchange for $46.9 million.
You have 1 more minute, Senator.
$46.9 million. Madam President, you go to National Flour Mills, it's the same problem. They were able to lend National Flour Mills $10 million US, the same NCB Global. They went to the National Insurance Board. They take $35 million to invest in Guardian Life. The same Guardian Life that has now been taken over by a fellow called Michael Leachin out of Jamaica. Madam President, they went to a place called Trinidad Nitrogen Limited, and they took almost $100 million and deposited where? On the account of NCB Global Finance. Madam President, we want answers. We want answers from the government of Trinidad and Tobago. We want to know, and the people are demanding, what is the relationship between the government of Trinidad and Tobago and NCB Global Finance? That is what we want to find out, Madam President. I thank you very much, Madam President.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, if what we just heard sounds like instant replay, it's because Senator Mark just repeated almost word for word the comments he made in the debate last week, which my colleague
on the right adequately dealt with. It seems like Senator Mark is determined to drag the name and reputation of a very reputable, long-standing bank of the Caribbean through the mud in Trinidad and Tobago. All because the bank, one of the staff members of the bank is related to a government minister. That is completely reprehensible behavior. It also appears that Senator Mark is seeking to prescribe to this government the modus operandi of other governments. When we issue contracts and enter into transactions, we do that in a manner that's transparent and defensible. So let me give you the facts of what gave rise to this particular transaction between UDCOT and the NCBJ. Madam President, in 2012, and I'll repeat the date, 2012, when this government was not in power, the then cabinet agreed to the conclusion of a memorandum of understanding between the Ministry of Health and the Federal Ministry of Transport, Innovation and Technology of the Republic of Austria on industrial cooperation in the health sector, and that the Minister of Foreign Affairs then was authorized to sign the MOU on behalf of the government of the Republic of Trinidad and Tobago. Pursuant to the signing of the MOU on June 29, 2012, the Ministry of Finance was provided with an offer from UniCredit Bank of Austria for the financing of 100% of Phase 2 of the design, construction, and completion of the adaptation of the Chancery Lane office complex as an extension of the San Fernando General Hospital in an amount of $53,705,000 by making available, one, an export credit facility of up to euros 32 million on the basis of cover by the official Austrian Export Credit Agency and any other credit agency acceptable to UniCredit Bank of Austria AG, and two, a commercial credit facility of up to euro 20,805,000. It should be noted that the commercial credit facility was required to finance the down payment, the value-added tax, and part of the local costs of the projects. In respect of this component of the financing, Cabinet in November 2012 determined that the amount of the equivalent of up to euro 20 million should be financed by a local financial institution. The then Cabinet in 2012 made that determination. Further to the above, Cabinet by May 9, 2013, agreed that CIBC First Caribbean International Bank Trinidad and Tobago Limited should provide a one-year short-term government guarantee financing facility in the amount of $180 million at a rate of 1.5% for UDCOT. This was, in effect, a bridging loan for to be converted to a longer-term financing arrangement. The bridging loan facility was initially due to mature in May 27, 2014. However, given continued undue delays in financing the long-term takeout of the short-term facility, the short-term facility with CIBC First Caribbean was extended 8 times, with the final extension ending in November 2018. As the November 2018 maturity of the short-term facility approached, the Ministry of Finance recommended a long-term takeout to be secured by the Ministry of Finance's request for proposal process, which would most likely secure the most competitive financing. So let me repeat, when we determined we wanted to replace the short-term financing with long-term financing, we decided to do that through an open tender. Accordingly, Cabinet, by Minute 1457 of August 20, 2018, agreed, among other things, to the takeout of the existing short-term facility in the amount of $180 million Pursuant to this cabinet decision and in consideration of the current GOAT debt maturity profile, a request for process for a fully underwritten $180 million 10-year fixed-rate loan facility were issued to 10 domestic financial institutions on September 7, 2018. Those financial institutions were Answer Merchant Bank, Bank of Baroda, CIBC, also a foreign entity, CIBC First Caribbean International Bank, also a foreign entity, Citicorp Merchant Bank, First Citizens Bank, JMMB Investments, NCB Global Finance, Republic Bank, the one that Senator Mark mentioned, Scotiabank Trinidad and Tobago, and the Trinidad and Tobago Unit Trust Corporation. These all were all invited to submit proposals under the request for proposal process. The financing options were comparatively assessed on the assumption of a 10% discount factor utilized in the present value calculations in accordance with standard international practice for evaluating financial proposals. The proposals were also evaluated on the basis of effective interest rate, fee structure, total cost, internal rate of return, and net present value of discounted cash flows. The final ranked evaluation relates the top 3 bids with the cheapest cost options. NCBGF was ranked and selected as the preferred bidder, having regard to all of those factors. Following the financial evaluation, the Ministry of Finance recommended to Cabinet that NCBGFL be awarded the mandate to arrange a 10-year fixed-rate loan facility in the amount of $180 million to facilitate the repayment of the existing UDCOT short-term facility. The Cabinet's agreement to the MOF recommendation was conveyed via minute 1665 of September 27, 2018, and the award of the mandate and letter of guarantee was issued by the Ministry of Finance to NCB on October 5, 2018 and October 9, 2018, respectively. Subsequently, loan documentation between NCB and UDCOT were drafted and approved at the 227th meeting of the Board of Directors of UDCOT held on November 8, 2018. The loan agreement effected was executed between UDCOT and NCB on November 8, 2018, and the draft guarantee has been forwarded to the Ministry of Finance for execution. Mr. President, the arrangement basis for this transaction was best efforts, which essentially means that syndication of the loan was permitted and financial institutions could join in the loan as initial lenders or later as qualified lenders. Sagicor Life Inc. joined in or contributed funding in an amount of $25 million. NCB remains the arranger and agent for this financing. The facility was fully disbursed on November 16, 2018, and the short-term facility with
Minister, you have 1 more
CIBC,
minute.
thank you, Madam President, was fully repaid on November 23rd, 2018. So, Madam President, there's nothing sinister or underhand about how this transaction was entered into or in choosing the person who extended the facility to the government. It is a reflection of what I mentioned last week, that a lot of the loan facilities that we had to go into arose out of transactions entered into by the previous government, which we have had to address, and it was done in an open, fair, and transparent manner. And NCB, despite who its managing director was, properly won the bid for this transaction. So if we can ask the other side to stop maligning our citizens and our Caribbean neighbors in a manner that is completely irresponsible. Madam President, thank you very much.
Senator Mark, can you withdraw what I just heard you say, please?
Yeah, Senator, your business in
Senator Mark, no. I have asked you, please, to withdraw that statement.
Okay, I withdraw, Mark. She not
Honorable Senators, The question is that the Senate do now adjourn to Tuesday, the 28th of May, 2019 at 1:30 p.m. Those in favor say aye. Aye. Those against say no. The ayes have it. This Senate now stands adjourned to Tuesday, the 28th of May, 2019 at 1:30 p.m.